senior counsel indicated that the Senate is a chamber or is a political chamber. There can never be something that is far from the truth, because in the case of Governor Wambora, that is Civil Appeal number 21 of 2014, the Court of Appeal had the opportunity of evaluating that position, and it came to a conclusion that when the Senate is seized of a matter of impeachment, it's not just a political chamber, but it converts itself into a quasi-judicial process. And that is why, my lady, my lords, under study order number 79, the Senate is required to take a special oath before constituting itself into a quasi-judicial chamber. On the question, one issue about justiciability of the process, it's our humble submissions, my ladies, my lords, that was ousted by the enactment of Article 3, Article 1, Article 10, 27, 25, 50, 165, and 159 of the Constitution. When the people of the Republic of Kenya enacted Article 3, it bestowed upon all state organs, any individual, to protect the Constitution. And therefore, there is nothing that is far from the reach of this court, insofar as the protection of the Constitution under Article 3 is in issue, insofar as the upholding of the doctrine of sovereignty is in issue, insofar as the application of Article 10, the principles of and the values of governance are concerned, and most importantly, the rule of law. How can it be that justiciability can be pleaded as a defense, yet the court is being told to uphold the rule of law, good governance, democracy, and the participation of the people? How can it be that this can be a defense when Article 165, 3D calls upon this court to interrogate whether anything said to be done has been done in accordance to the Constitution? Was the impeachment of the Deputy President not done within the Constitution? Was it not sanctioned by the Constitution? How then can it be from the reach of this court? How then can it be a defense when Article 27 creates a doctrine of equality before the law? How can it be argued in that respect? Allow me to address what Professor Ojiena addressed. The question of the two-tier trial. Yes, it was a two-tier trial, but was the Deputy President granted an opportunity to be heard? My lords, my ladies, look at Article 1 and Article 94 of the Constitution as read together. Article 94 provides for the creates Parliament and provides that it's a representation of the people. How can it be a representation of the people and you lock them out when it comes to their participation on a question of the impeachment of the Deputy President? How can it be that Parliament can be immune from the application of Article 1 and usurp the people's power when the people are supposed to directly participate in giving their views under Article 118 of the Constitution? Ladies, my lords, you are invited to look at the trial at the Senate, and you are told that it was time-bound. My ladies, my lords, it's a misconception and misreading of the Constitution under Article 147, 145. My ladies, my lords, the only time Senate was limited was when or if it constituted itself in a special committee. If what transpired in Parliament in the Senate was a matter that was under Article 145 clause 6, then we could say that the 10 days period mattered. But it is important for us and imperative for us, my ladies, my lords, to note that when the Senate sat to hear the impeachment of the Deputy President, it is sat as a plenary of the House. And as such, the 10 days were not therefore applicable in that circumstances. Number two, my ladies, my lords, you've been told that the Deputy President avoided to appear for his defense and that he was represented. But my ladies, my lords, if my good learned friend professor was candid with the truth, he would have drawn your attention to the provisions of the rules of procedure for the removal of the president and deputy president, starting order number 78, 9, and you would have drawn your attention to rule number 6. And on that rule number 6, he would have told you that the rule provides that where the president chooses to appear before the Senate, the president shall be required within 3 days of the invitation under sub rule 4 or rule 4 on the date specified in the invitation to file an answer to the charge with the office of the clerk of the Senate, in which the president shall set out. He would have told you the mode of appearance. 1, the president's response to the particulars of the allegations. Number B, how the president, and in this case the deputy president, proposes to appear before the Senate. And that rule has created through mechanisms or through 3 ways in which the deputy president would have appeared. 1, whether in person. 2, by advocate. 3, in person and by advocate. The operative word in our case, my ladies, my lords, is number 3, in person and by way of advocate. The deputy president appeared in person and by advocate. And as such, my ladies, my lords, when he was taken ill, the question of then appearing in person and by advocate was an issue. And number 2, my ladies, my lords, he was a witness and the only key witness before the Senate. How then could you say that there was fair trial and Article 50 of the Constitution when the only fundamental infrastructure of the trial is unavailable? My ladies, my lords, permit me to address you on what was submitted by Mr. Somane. It's unfortunate that he has chosen to have a very lean and thin way of looking at the application of Article 149 of the Constitution. There can never be anything that is misleading to say that that article should be read in isolation of other provisions of the Constitution. If you choose to read Article 149 in isolation, you arrive at the absurdity that Mr. Somane and his colleagues have arrived at. I urge this honorable court to look at the import of Article 259 of the Constitution, which provides for the manner in which the Constitution must be interpreted. If Mr. Somane was candid with the truth, he would have invited this honorable court to harmonize and purposely read into Article 149. My ladies, my lords, the reading of Article 149 in a purposive and in a harmonious way would have told Mr. Somane that then Article 99 and Article 197 of the Constitution is imperative. And therefore to say that the IBC had no role in the process of the nomination of Mr. Kindiki is absurd, is not true. The fact is that if Mr. Kindiki was to successfully become the Deputy President of the Republic of Kenya, is it then true that he can become a Deputy President who has not qualified under Article 99 of the Constitution? Is it therefore true that he can become the Deputy President if he has not qualified under Article 197 of the Constitution? Who then determines this qualification? Is it the President? Is it Mr. Somane? Is it Ndegwa? Who determines that qualification? If it is not the IBC.
My Lord, there is something that Mr. Njiru is submitting on, which touches on very critical facts concerning Professor Kindiki as to his qualifications. And we are all familiar with the qualifications of Professor Kindiki.
I think the last time Mr. Kamodo was before you, he said he has no client.
I have a client, the 10th respondent, the United Democratic Alliance. I ceased to act for the other client because it would have been illegal. But I have a client. So I'm properly on record. And it is important that the record be made straight with regard to Professor Kindiki's qualification, and including what had been cited in the affidavit that he was not a member of the UDA for 3 months, which is not a requirement in law. No law requires you to be a member of a political party for 3 months for you to ascend to the position of the deputy president, which Professor Kindiki has acceded to. And secondly, it will be
a issue that is being handled. Yes. So we're going to have the opportunity to answer it, because the law is the opposite of what you say.
It was raised by Mr. Njiru. I'm just clarifying.
It's not the time to raise that issue. That is my submission, my lord. He is going into the merits.
But then Mr. Njiru may
just let's sort it. My lord, it is on record from Professor Kindiki. I think if Mr. Ndegwa, my very good friend, I usually call him the Black Bull, would keep off rehashing his application.
The black what?
Bull. That's what Ndegwa means. If my friend the Black Bull would keep within the remit of a rejoinder and a reply, will not be having all these interjections. I've been resisting that because I always try to avoid appearing cantankerous. But if he keeps rehashing his application, unfortunately, then as the person on record for Professor Kindiki, I will be forced to be cantankerous, which is not my nature.
Let's give Mr. Njiru time to.
I am also satisfied, my lord. My lords, finally, let us distinguish the Kindiki case from what is before you. What is before you, my ladies, my lords, is a case where a party was not granted an opportunity to be heard. It is a question where there is a violation of Article 27, violation of Article 10, violation of Article 50, and violation of Article 25, that the right to be heard cannot be derogated. What was in Kindiki, my ladies, my lords, is that the Kindiki deputy governor underwent the full trial at the Senate. And therefore, my ladies, my lords, those facts are distinguishable. Finally, my ladies, my lords, Mr. Kumbo urged you to fight that there will be crisis if the position of the deputy president is not filled. I want to remind you that Act 139 and Act 146 has created an avenue and a remedy where if the president is given to be impeached, the remedy is that the Speaker of the National Assembly, under Article 146, takes over for 60 days, and under Article 139, if the two of them are not able to take office, again the remedy is that the Speaker takes over. So we are not in a crisis whatsoever, my ladies, my lords. I invite my learned friend, Senior Mr. Kibe, to proceed.
My Lord, I start with the assurance to my learned colleagues that I know what you have replied to the issues of law. So I hope I can proceed without a lot of interruptions. My Lord, I start with the submissions by my learned colleagues, Professor Mutembei. I agree with him a lot that you cannot be able, we are entitled to a legal opinion, but we are not entitled to a set of facts. And therefore, the set of facts is as they are. But my Lord, in saying this, it is important to remember that what also litigants are not entitled to, and this is the